Thank you, Jane, for being such a passionate and empathetic leader of the Alex Panton Foundation. But more so, I want to thank you today on behalf of the entire audience for allowing yourself to be vulnerable in order to help others. Thank you for having the strength and the courage, not just today, but every day, in leading the Alex Panton Foundation. Alex's life continues to help others through the Alex Panton Foundation. We love you, Jane. I'd like to acknowledge Ms. Julie Hunter, Parliamentary Secretary for Planning, Lands, Agriculture, Housing, Infrastructure, Training and Heritage, and our Parliamentary Secretary, Heather Bodden. Thank you so much for joining us. We really appreciate you being here today. Now I'm delighted to welcome Chief Justice Margaret Ramsay Hale to speak on When the Court is Not Enough, Understanding the Limits of the Law in Protecting Children at Risk.
Hello, everyone. I come with my napkins because I fear I'm going to trigger myself in my speech. Thank you for having me. It's a true privilege to be here. I want to start by acknowledging the immensity of the work that Jane and her family have done in establishing the foundation, turning their grief into action, and to thank them for it. I have the unenviable task of speaking after Jane, the governor, about Gilgamesh, after the minister who has preempted most of my speech, which was a call to action, and after Jane, who has shared a personal story, which, apart from the ending, I experienced too. I even wonder now, since I'm speaking at the coffee break, whether I should skip my story and just move to my call to action. I will start where Jane started, though, about listening to understand and not respond. It sounds simple, but in practice it requires restraint. When we feel challenged or when what is being shared with us makes us uncomfortable, whether as parents, teachers, or professionals, we instinctively prepare our reply. Sometimes it sounds like, yes, but. The yes acknowledges or appears to acknowledge what you're saying, but the but, it cancels it out. It signals that what follows after matters more than what has just been said. It tells the speaker, subtly but unmistakably, that we are moving on to our own justification. Often, as Jane said, with children, it is subtler. With children, we may move quickly to reassurance, advice, correction. It will be fine, Alex. Just ignore it. You need to try harder. You know the BetterHelp ad? The fellow is depressed, and in the ad, his friend says, you just need to go for a walk. Look on the bright side. All of it is well-intentioned, but in doing so, we sometimes move too quickly past what the child has actually placed before us. Now, I work in a court, and courts are designed to listen. The essence of a fair hearing is that every party is heard before judgment is passed. We listen carefully before responding. But listening is not the weakness of the court. The limitation lies elsewhere, because even when a court listens well, it is usually intervening late, and the tools at our disposal are constrained, particularly when dealing with children at risk, on whatever part of the continuum they are. What is a continuum of risk? unmet needs, leading to behavioral distress, leading to exclusion, marginalization, and ultimately contact with the court. Not always, but often enough to matter. As a parent, I have seen how easily behavior can be misunderstood. And I want you to know I'm talking to you today. I'm not a professional. I am really just a mom and a judge who has worked with children who struggle with mental health issues. I should say, as a mom who has lived with, and a judge who has worked with children with mental health issues. My youngest was described as energetic in kindergarten. She struggled to color between the lines. On sports day, she struggled to run the obstacle course. One of the obstacles was to climb under a rope and go over a box. 5 feet before she reached the rope, Lauren had dropped to the ground and she had started to crawl. And you wouldn't believe it, but she stood up in the rope. She got completely tangled in it, and behind me in the stands at the Truman Bodden Sports Center, the parents laughed and I cried. As she progressed through the lower school, the language changed. She was now disruptive. She continued to fail miserably at athletics. When they threw the ball to her at T-ball, she ducked. In middle school, she began to fail at friendships. There was a day when her entire class put her in Coventry. Don't know if you know that expression, it's English. And it's a day when nobody spoke to her, but pretended that she didn't exist. I remember a time, I'm sorry, I am triggered and I need one of the professionals to meet me outside. I remember a time I was always being called into the office to discuss her behavior. I asked Emily to remind me it was Miss Devlin. I lived there. At home, like Alex, she exploded with anger, and the anger was directed at me. It was a really difficult time for both of us. She was a very unhappy little girl. Eventually, when she was 12, thank you, Wayne, for the napkins. Eventually, when she was 12, she was assessed and diagnosed with what the psychologists called profound ADHD. And we, that's me and the school, we became to understand how it affected her behavior. We discovered that her ADHD affected not only her behavior, but her fine motor skills. It's why she couldn't color within the lines. Her ADHD was so profound, it affected her gross motor skills. It's why she couldn't do the obstacle course. It affected her ability to regulate her emotions, which is what was impacting her friendships. She was trying very hard to be like everyone else, and it was not working. And so it was no surprise to me that she was also diagnosed at the same time with oppositional defiant disorder. But that, to me as a mom, was a technical way of saying that she was tired and angry of being left out and being left behind. And all that anger she unleashed at home after school, that was not defiance. That was a child who was exhausted from containing herself all day, trying not to be the problem. And I was her safe place because she could shout at me and I would always love her. She wasn't so sure about the rest of the world. The importance of her experience, and it was hers, not mine, hers, was that it changed me as a judge, because I started my judicial career in the family court. And I came here where we don't have a dedicated family court, but we deal with children. It changed how I approached the work, and it improved the way the court operated. I began to see similar patterns in the children appearing before me and began to ask the question, was behavior, which was being labeled as defiance, masking anxiety? Was repeated misconduct masking a learning difficulty? Was emotional volatility masking trauma or neurodiversity? A child is never only their behavior. And so we began requiring psychological and educational evaluations for every child that walks through the doors of the court, because I felt the court should not be responding to symptoms without first understanding the child. Because sometimes when a child is properly understood, the trajectory can shift. But here is a harder truth. And I must say that this was 20 years ago, and ordering education and behavioral assessments was brand new. In fact, the court caused the government to hire its first educational psychologist, but I just dropped that in. But here is the harder truth. By the time many children reach the court, patterns are already entrenched. Risks have crystallized. The children are well beyond parental control, or an offense has occurred. Do you see my language? Did I say the child committed an offense? I say an offense has occurred. The child has found itself in conflict with the law. Not all children have adults with the capacity, resources, or stability to advocate for them like my daughter had. And by the way, she is now in her 30s and thriving, and I know you wanted to know. And I can promise you, she gave me permission to tell her story because she thought it might make me more relatable. Judge Dredd. It might make me more relatable, and it might help other parents who find themselves in my position. So not all needs can be met by families, however loving. Some children depend on systems, and systems do not always hear them in time. And when systems fail to respond to the needs of children early, the court is really not a solution. It becomes a witness to the harm that has already been done. So let me tell you about another child. The child in this story, we call her X. Her story did not unfold outside the system like my daughter's. Her story unfolded entirely within it. And she's a child who, despite every effort, has remained beyond the court's reach, even as she is under the court's protection. She is 13. She's facing several charges before the court for violence and drug possession. She's been diagnosed with early onset bipolar disorder, severe ADHD, childhood onset conduct disorder as a more pronounced form of oppositional defiant disorder. She had her first manic episode at 11. You might be surprised to understand that the manic episode was characterized by aggression. We continually misunderstand children's aggression, which is really the outward expression of their inward feelings of depression and self-harm. I have to just pause here and remark that it is incredible to me that some people think ADHD is a made-up diagnosis to excuse bad-behaved picnic who have bad parents. Still, can I just say that the difference between my daughter's story and Child X is 20 years, and we seem not to have made any progress at all. So she is in the care of the state, and she is before the court. We have 2 children, 2 different outcomes. So understand this. The court can make care orders, it can order assessments, it can order overseas placements, it can require compliance with treatment, it can monitor progress through reviews, it can ensure procedural fairness, it can give that child a voice, but the court cannot create a program, fund services, build a facility, staff a mental health unit, compel a service to exist, provide therapy or treatment, or act as a substitute parent or clinician. These solutions lie with the state. And I'm pleased to hear the minister who preempted me speak about the minister's plans to engage with these issues. The solutions also lie with the community, with organizations like the Alex Panton Foundation. Over the years, I have seen parents come before the court who basically said to me, "You deal with him." These parents were not indifferent. They were exhausted. That moment was not a failure of love. It was a failure of coordinated support for parents who lack the resources and the right tools to parent such a child. Child X's case highlights the lack of proper mental health residential care for young people with critical needs. In this reality, because I know what the minister's plans are, but in this reality, this child was refused by several overseas facilities because of the severity of her presentation. And when she secured a place, it was for a short term only, when what she needs is long-term residential care and intervention. So the case also highlights the limitations of the courts to whom everyone turns when early intervention has not been made or when no other alternative can be found. Schools, families, social services, clinicians, youth workers, all of these actors have daily proximity to a child, and they have the ability to intervene early. The court does not. The statistics that the court publishes annually suggests that we are seeing fewer children before the court, fewer children being brought before the court for care and protection. But as the minister noted, 12.5% of students have mental health issues. So it would be unwise to draw simple conclusions from statistics alone. A reduction in court appearances may reflect diversion from court. It may reflect informal resolution. We don't know, and the data deserves careful analysis. But what I do know for sure is that there are children in our community who are presenting with increasingly complex behavioral and mental health challenges. So I don't care if the number has gone down. They're presenting with increasingly complex mental health challenges. And this calls for a thoughtful response. So, I was speaking about the limitations of the court. We cannot create services by judicial order. We cannot substitute for coordinated therapeutic provision. We cannot treat what has not been resourced, but this is not a counsel of despair. Because I have seen what happens when adults listen differently. When schools ask, what is happening here? Rather than asking, how do we stop this behavior? When families seek support early, and when services coordinate rather than operate in silos. In those moments, children change direction. So lighting the way, turning hope into action, should not be about optimism as a feeling, rather responsibility as a practice. Hope is early intervention. Hope is coordination. Hope is building systems that share information responsibly and act before behavior escalates. Hope is ensuring that when children do come before the court, they encounter understanding and somewhere meaningful to go next. Courts will always be necessary. I remember one of my Grand Court opening speeches, I called yet again for the building of a new court. I'm going to have to spend some time on this in another forum to explain that a family court, for instance, which has all the services in the same facility. You go from court downstairs to social services. You go from court upstairs to mental health. That these kinds of institutions are necessary, but for another day. I will say that after I called for a new court to be built, somebody called in to Sandra's show and said, we don't need a more court, we need more education. But the truth is, I'm sorry to say that we're not all the same, and there will always be a place for courts, even if they deal with persons other than our children. But courts, although they're necessary, should never be the first meaningful intervention in a child's life. If we listen earlier, act earlier, and could coordinate better, the court becomes what it should be, not the place where distress finally lands, but the last safeguard in a system that is already working well. The fewer children we see there, the better we will all have done our jobs. Thank you.